There is a room somewhere in the United States Patent and Trademark Office. Not a metaphorical room, but a physical one, with locked filing cabinets and restricted access protocols, where inventions go to disappear. Not because they failed, not because they were fraudulent or redundant or commercially unviable. They disappeared because they worked, because someone somewhere in the architecture of the American national security apparatus decided that these ideas were too dangerous, too sensitive, too consequential to be allowed to enter the world. They disappeared by law, and most of them have never come back. As of fiscal year 2025, there are 6,543 active secrecy orders currently imposed on patent applications in the United States. 6,543 inventions, each one representing years of a human life, dedicated to solving a problem, to building something new, to adding something to the sum of human capability, sitting in a kind of legal amber, frozen, silent, invisible. The inventors are alive, or they were alive, or their estates carry on waiting. The applications exist, the technology exists, but for the world beyond those locked cabinets, none of it does. This is the story of the patent purgatory. It is a story about the machinery of secrecy, about the collision between national security and the fundamental human drive to create, and about what happens to innovation and to innovators when the state decides that knowledge itself must be quarantined. It is a story told in statutes and case numbers, in redacted documents and decades of silence. And it is a story that is, in many ways, still being written. To understand how an invention disappears, you first need to understand the legal mechanism that makes disappearance possible. That mechanism has a name, Title 35 of the United States Code, Chapter 17, and more specifically, Section 181. Its formal title is the Invention Secrecy Act of 1951, though its roots run deeper than that, back to the wartime emergency provisions of 1917 and the more expansive controls enacted during the Second World War. Congress codified and formalized these powers in 1951, and in doing so, created one of the most quietly consequential pieces of legislation in the history of American intellectual property law. Section 181 grants the Commissioner of Patents, acting on the directive of designated government agencies, the authority to impose a secrecy order on any pending patent application. The threshold is intentionally broad. The order can be issued whenever the publication or disclosure of the invention might be, quote, detrimental to national security. That phrase, detrimental to national security, carries almost no definitional limit. It encompasses weapons technology, obviously, but it also encompasses energy systems, communications hardware, cryptographic methods, propulsion technologies, and increasingly fields that the drafters of the 1951 Act could not have imagined. Artificial intelligence architectures, quantum computing protocols, and advanced materials science. The net was designed to catch everything that might matter, and it does. Once a secrecy order is imposed, the consequences for the inventor are immediate and sweeping. The patent application cannot be published. It cannot be disclosed to foreign nationals. The inventor cannot discuss the technology openly, cannot seek foreign patents, cannot license the invention, cannot, in most cases, even fully explain to a lawyer or a business partner what they have built. The invention enters a kind of legal stasis. And here is the mechanism that transforms a temporary restriction into a potentially permanent one. The secrecy order does not expire automatically. It must be renewed. Every year, the relevant government agency, typically the Department of Defense, but also the Department of Energy, the NSA, and others. Reviews active orders and decides whether to maintain or rescind them. The renewal process is internal, classified, and effectively unreviewable by any outside party. The inventor has no meaningful right of appeal. They can petition for rescission, but the petition goes back to the same agencies that imposed the order in the first place. There is no independent judicial review of the national security determination. There is no sunset clause built into the statute that forces a reckoning after 5 years, or 10, or 20. There is only the annual renewal year after year, decade after decade, until someone inside the machinery decides the danger has passed. The statute does provide for compensation in cases where the government secrecy order causes the inventor financial damage. Section 183 creates a right of action against the United States for compensation, but the threshold for recovery is high. The process is cumbersome, and the historical record of successful claims is thin. The inventor has the right to ask. They do not have the right to receive, and they certainly do not have the right to know why their invention is being held, or for how long, or what specific element of their technology triggered the original concern. This is the machinery. This is how 6,543 inventions disappear. But statistics are abstractions. The weight of the patent purgatory becomes real only when you hold specific lives against it. Let us begin with Gerald F. Ross. Gerald Ross was an electrical engineer with a specific and sophisticated obsession: electromagnetic pulse propagation in radar systems. In 1977, he filed a patent application for a technology he had developed related to impulse radar. The application was technically sophisticated. The invention was real, and the patent office determined it met the criteria for patentability. It also met the criteria for secrecy. An order was imposed. Ross was notified that his application was classified. He could not disclose it. He could not commercialize it. He could not, under penalty of federal law, tell the world what he had built. Gerald Ross waited. He continued working. He submitted petitions. He corresponded with the patent office across years, and then decades. The secrecy order was renewed, and renewed again. Year after year, the machinery of annual review ground forward, and year after year, the determination was the same. The Ross radar technology remained sensitive enough to warrant continued suppression. The order was finally rescinded in 2014. United States Patent number 8,754,801 was granted to Gerald F. Ross in that year. 37 years after the original application. 37 years. To put that in human terms, an engineer who filed a patent application in 1977 at the height of the Cold War did not receive his patent until Barack Obama was in his second term as president. The technology that Ross developed in the era of analog computing finally received its legal recognition in the age of smartphones and cloud infrastructure. Whatever commercial window might have existed had long since closed. Ross received his patent. He did not receive his opportunity. The Ross case is extreme in its duration, but it is not anomalous. It represents the purest expression of what the secrecy order system does when it functions. In its own terms, correctly. The technology was sensitive. The order served its purpose, and the inventor absorbed the cost, personally and professionally, that across the span of a career. Now travel back in time to a different kind of inventor and a different kind of secret. William F. Friedman is one of the most significant figures in the history of American cryptography. He essentially founded the modern discipline of signals intelligence analysis in the United States, breaking Japanese diplomatic and military codes during the Second World War, and laying the intellectual groundwork for what would eventually become the NSA. He was, in the truest sense, a man whose mind was itself a national security asset. And in 1944, he filed a patent application. The application concerned a cipher machine. The technology was sophisticated, the security implications were obvious, and the secrecy order arrived swiftly. What followed is a masterclass in the particular cruelty of the system's interaction with a brilliant and temperamentally fragile man. Friedman spent years in a state of professional and psychological tension. He was not simply waiting for a patent. He was a man who had given his intellectual life to his country, who had done so at enormous personal cost, including at least 2 documented psychiatric hospitalizations, and who found himself trapped in a system that would not acknowledge the full scope of what he had contributed. His cipher machine patent application sat under secrecy order from 1944 until 1958, when the order was finally rescinded and United States Patent Number 2,877,565 was granted. 14 years. For a man of Friedman's stature, 14 years of suppression represented not merely a commercial inconvenience, but a denial of professional recognition. The patent was ultimately granted. Friedman received it. He died in 1969, and the full extent of his contributions continued to emerge in declassified documents for decades after his death. The Friedman case matters because it illustrates something essential. The system was not designed to protect Friedman's interests. It was designed to protect information. Those are not the same thing, and when they conflict, the information wins. The inventor is collateral. The third case brings us into more recent history, where the stakes are measured not in signals intelligence, but in kinetic force. In 1990, a patent application was filed for a technology involving multi-charge munitions, specifically engineered for penetrating and defeating reinforced concrete targets. The underlying problem was a genuine military challenge: how to design a munition that could defeat bunkers and fortified command posts with greater reliability than existing solutions permitted. A secrecy order was imposed, the application was held, and it remained held for 26 years, through the end of the Cold War, through the Gulf War, through September 11th, until 2016. When United States Patent Number 9,476,682 was finally granted. The assignee on the patent is Kinet IK Kinetic-Q, the British defense technology company. The technology's journey spans the entire post-Cold War era. It was filed when the Berlin Wall still stood. It was granted when drone warfare had become routine. 26 years is not an aberration. In the universe of secrecy orders, it is an outcome. It is what the system produces when it functions without friction, without external pressure, without a compelling reason to change course. And it raises a question that the statute does not answer. At what point does the protection of information become, in practice, the suppression of development? At what point does the classified filing cabinet become simply a graveyard for ideas that could have mattered? There are those who study these questions with the tools of economic analysis, and what they find is not comforting. Daniel P. Gross, an economist for the NBER, has conducted one of the most rigorous analyses of the economic consequences of invention secrecy ever published. His examination of the wartime dataset provides a quantitative foundation for what case studies can only illuminate anecdotally. The core finding of the Gross analysis is this: Secrecy orders do not merely delay individual patents. They interrupt the chain of cumulative innovation. They break the connective tissue of technological development. Because patents are not simply legal documents, they are also, by design, published disclosures. When you receive a patent, you disclose your invention to the world. Other inventors read that disclosure, they build on it, they cite it, they identify the gaps. This is how technological fields advance. When a secrecy order is imposed, that disclosure never happens. The patent simply does not exist in the public record. The downstream inventions that would have built on it are never filed. The damage is not linear. IT compounds. Each suppressed patent creates a shadow, and in that shadow, other innovations fail to appear. Gross's analysis calculates the foregone value of suppressed innovation at over $500 million. $500 million of foregone value, calculated for one historical episode in one country across a period of a few years. When you apply a private value proxy in the range of $810,000 per patent, you begin to see the architecture of a genuinely massive economic injury. Real, large, and permanent. The wartime suppression, for all its scale, was temporary. But the 6,543 active secrecy orders as of fiscal year 2025 represent a standing population, a permanently maintained inventory of suppressed innovation that has persisted for decades. The wartime data gives us a lower bound for the economic cost. The modern inventory suggests we are paying that cost continuously, year after year, in the silence of the locked filing cabinet. What is the calculus that produces this outcome? It is not malice. The officials who impose these orders are doing what they believe their responsibilities require. They are asking whether the disclosure of a technology would provide meaningful advantage to adversaries. In many cases, the answer is genuinely yes. But the system has no internal corrective for failure. The agencies have every incentive to maintain orders. Maintaining an order is costless to the agency. Rescinding it carries risk. The inventor has no meaningful lever to apply. The Patent Office has no authority to override a national security determination. The result is a system that defaults to continued suppression. Not because it serves the national interest, but because the path of least institutional resistance runs through the annual renewal. This is administrative archaeology in its most precise sense. Layers of process deposited over decades, each one reasonable in isolation, forming in aggregate a structure that no one designed and no one fully controls, but that shapes reality as surely as any deliberate policy. The implications are not abstract. They are arriving now. In the fields that will define the next era of technological competition, artificial intelligence, and specifically the architectures of large language models, is being actively scrutinized. Patent applications touching on AI-enabled cryptographic systems are moving through the Patent Office right now, and some proportion of them are receiving secrecy orders. We do not know exactly how many because the existence of a secrecy order is itself often classified. We know the aggregate number. We do not know the distribution. We cannot see the shape of the missing. Quantum computing presents an even sharper challenge. The development of machines capable of breaking the world's digital communications is the single most significant national security concern of the current era. Patent applications related to quantum error correction are being filed right now, and some of them are under secrecy order. The inventors are working in the domain that will most profoundly reshape the balance of power, and they have been told that their work cannot be disclosed. The question is not whether these orders are legally authorized. They are. The question is whether the system, with its structural bias toward renewal and its absence of independent review, is capable of making these determinations with the precision that the stakes demand. A secrecy order imposed in 2024 and renewed without review until 2040 becomes the next Gerald Ross problem. A field-defining technology held in amber while the world builds around it. There are 6,543 inventions in the patent purgatory as of fiscal year 2025. Each one is a fact. Each one has a number. Each one has a name attached. Most of them cannot tell you what they invented. Some of them are no longer alive to tell you anything. The Invention Secrecy Act was written by people who understood, viscerally, the cost of technological surprise. They built a mechanism that could, when necessary, stop the world from knowing what America knew. The mechanism works. It has always worked. Question is what it costs to make the mechanism work, in the specific, irreplaceable value of human creative work that enters the system and does not come out. Gerald Ross waited 37 years. William Friedman waited 14. The munitions designers waited 26. These are not cautionary tales. They are data points. What we can calculate is the shape of the silence. We can measure the citations that didn't happen, the companies that weren't built, the technologies that didn't emerge. We can read the statute and identify the structural features that make the injury self-perpetuating. We can tell the stories of the inventors who waited and who are waiting still. And we can ask the question that the system, by design, does not answer. What is being protected exactly in that locked room? What remains so sensitive on that it justifies the continued suppression of an invention filed when Jimmy Carter was president? Or when George H.W. Bush was president? The system knows the answer. The system is not required to tell us. That asymmetry is not a bug in the Invention Secrecy Act. It is the feature around which the entire mechanism is built. The patent purgatory is not a failure of the system. It is the system, working exactly as designed, 6,543 times over, and counting. Thank you for listening to this briefing from the Forbidden Archives.